as media practitioners, as civil society actors that speak and voice concerns of citizens, it behooves all of us to ensure that whatever is proposed in this and many other bills are scrutinized thoroughly, so that they do not take away with the left hand what the Constitution guarantees with the right. As you know, Kenya has been in the grey list because of those acts of terrorism and so on. The global mechanism set up by FATF and enforced by ESAMLAG, the Eastern and Southern Africa Anti-Money Laundering Group, did assessment of Kenya and found that whereas Kenya has passed many laws, some of the laws that they have passed in its efforts to combat terrorism and money laundering have had unintended consequences. And I think some of the provisions that are being flagged out in this bill are those that are likely to keep Kenya more in the grey list as opposed to getting him out of the grey list. And so we must also caution government that yes, we are aware that you are making every effort to get the country out of the grey list, but this is not the best way of how to go about it. It does not, warrant the kind of infringements that we see, potential infringement that we see in this bill. And so one of the tactics governments use, and I've seen elements of it in this bill, in this amendment bill, is to overregulate. And so concerns that have been raised by the previous speakers about duplicity is intentional. It's not by mistake. Governments want to overregulate and make sure that they can charge you or arraign you in court under any of the many laws that they pass, including the proposed amendments in the Computer Misuse and Cybercrime Act. And so, as a key stakeholder in the civic space, we join the media in raising these concerns, in amplifying the voices of concern that have been raised already, and which the civil society ably pointed out at a day-long workshop, which we held on these amendments some time ago, and which we have had the opportunity to share and ventilate on with the committee, the Departmental Committee of Parliament that is concerned. And so we are hopeful that based on the recommendation that the committee has made, that the bill be adopted, but with the amendments that have been proposed, I think this forum can reinforce some of the concerns that we raised, so that they do not see it as if, it's just of civil society in their characteristic style of fault finding that is faulting certain provisions of the amendment bill. And so we want to believe that as media practitioners, you will help us highlight some of these very, very legitimate concerns, and which we can then, perhaps through CARA, consolidate into a supplementary memorandum and share with the committee concerned, so that these issues that are still sticking out can be taken on board.
The Kenya Editors Guild, we are concerned especially the duplication of these amendments. We have seen the computer misuse bill, and also the kicker, which we are, they are bringing almost the same amendments, and you can almost tell that there's hurry in how the MPs or the members who are pushing these amendments, they are driving them. And what is also concerning are these individual hefty fines that are being recommended by these two bills. And we, as a media fraternity, we should take it upon ourselves to make more noise and ensure that the MPs and this committee listen to us, because we also worry of the timing and and the motive of these two amendments.
Today we are gathered here with the media practitioners to talk about the cyber misuse and computer misuse and cyber amendment bill. We have been on this process for the last several months, and what we have been looking at is the amendment process that is currently taking place. We did prepare a memorandum after consultation with a number of stakeholders in the media space, and we identified certain issues within the amendment bill that are really of concern to us. So what we did, we put that together. We engaged the ICT committee at the National Assembly, and what we are trying to achieve is to make sure that even as we talk about the amendment of the Act, we are not clawing back on what the Constitution has already given us in terms of media freedom and even human rights and the rights of people of this country. So we've been able to highlight some of these issues. For instance, the bill proposes some very punitive fines for those who have been found to offend certain clauses of the bill. So we did indicate that these fines need to be relooked, needs to be reduced, so that we don't really stifle media freedom. We also noticed that there's a lot of ambiguity in certain definitions. Like the bill talks about illegal activities without defining what exactly is an illegal activity. It also gave sweeping powers to the CS in charge of ICT to be able to close down website if they think somebody is engaged in a legal activity. We thought this was not the right way to do it. So one of the recommendations we made is that if there's a suspicion that somebody is involving in illegal activity using the media space, then we must go through the due process. We must go through the court, let the court issue an order and confirm that this is a legal process. So let the court issue an order for action to be taken. And even if the court issue an order, we are saying the first order should be that that particular offending act or posting or information should be brought down. It's only at the point where the person has refused to take that action that now we can bring down the website. So essentially, these are some of the things that we looked at, and we thought that we are really going to crowd out the space that we are enjoying in terms of freedoms and rights, and we need to push back so that we don't have an amendment that is actually going to be contrary to the Constitution. So today we gathered here to engage media practitioners, the journalists, the editors, so that we can be able to share with them what exactly the amendment is about. Our first step was to have this conversation and get the journalists. We are going to have a series of online campaigns in the social media to highlight some of the key issues around this amendment process, some of the key provisions that are being amended, and of course targeting both the media, the journalists, and also the general public, because we want as many people as possible to understand exactly what is going on and be able to take action. Because if you don't push back as a nation, don't push back collectively, then some of these offending provisions are going to go through. And once they go through, then we are in trouble, because now it is law and we have to comply. So one of the things that we are doing is to invest a lot in public sensitization. So like you say, we are going to continue engaging with the media. We are going to engage the general public. We are going to have a lot of online campaign, social media campaign, just to make sure that we all understand what is going on. Ultimately, we are hoping that the issues that we've raised, that we've identified as offending and as being retrogressive in terms of progressing our freedom and rights, can actually be addressed. And the final outcome through this amendment, because what they're trying to achieve is that once the process is complete, then we'll have a new act, so to speak, that now reflects this amendment. So we hope that the final outcome, the final act that will come out of this process will actually be progressive rather than retrogressive. And can only be progressive if the issues that we've highlighted together with other stakeholders are actually addressed and are reflected in the final document. So that's what we hope to achieve. One of the issues that we raised was the powers of the CS to be able to single-handedly bring down a website because they think somebody is doing an illegal activity. So the question we're asking ourselves, what is a legal activity, number one? And as the CS has the powers to decide on his own that this is illegal and this is not legal. So the initial proposal in the amendment bill was saying that that is the powers of the CS. But we said that that's okay, but can we have a determine what is illegal? So we say that before the CS takes any action, let us have a court process. Let us go to court. Let the court determine and decide that truly this is an illegal process. And even if the court determines that, the first action should not be to bring down the website. The first action will be to tell the offender to remove that particular information that is offending, so that there's a remedy. So we only come to the point of bring down the website if now the offender has been instructed to remove that information and they refuse. And now we say this is now a different case altogether. So that's one of the major wins for us, because if we left the way it was going to be abused, it was going to be misused. And if the CS doesn't like your nose, he'll say, I'm bringing down your website. And nobody will question, because that is the law.
The world has moved digitally, and with digital spaces where we are engaging, communicating, even delivering services. And so governments are also trying to see how do they balance between control, especially the governments that are trying to inhibit democracy, and others, how do they facilitate access to information for people to communicate. And that's a global trend and a global challenge. And so there is need, and I agree, for us to look at the Kenya Information and Communication Act to see what is it that is providing. It's also good for us to just generally accept that we have all manner of people in society. We have people who have good intentions, and so they will use the internet positively, but you also have people with not good intentions. So sometimes you use the internet in a negative manner. So you still have to have balance. So when someone, for example, is killing another person and they want to broadcast that online, you know, that is already someone whose actions will need to be controlled and regulated. But I agree there's need for us to review that, the bill, and see what it provides. So the other one is about the safeguards and the human rights defenders. So like one of the things we did around that safeguard was to challenge that provision where the committee was being given power to issue a directive. Remember, the committee is administrative. It is not an institution itself. It is not does not have like a legal mandate. It's people, officers coming from different government agencies. So they were given power to issue directives if it's proven, but based on what? So the safeguard around that was for us to push for someone to go to court. And we thought that the courts are not perfect, but it is they are the institutions that we have given the power through the social contract to administer our disputes. And we thought that the best way to administer that is for officers to go to court or to link declaration of an illegal activity based on a court conviction. Because currently, someone just decides that whatever you're doing is illegal. So they define what is illegal. So what we did to support the human rights defenders, and of course all of us, is to try and challenge that provision, because especially that term, child pornography, there is a general consensus in the legal field of what is child pornography. So if it's adult information, if you're above 18 years, and it's your messaging, it's your photos, that cannot be child pornography, because you're not a child. So there's already a clarity around what is child pornography. But there's no clarity as to what is illegal activity, unless you go to court. So that's the reason why we thought that that clause was most material for us. So I think that's why we thought that is good. But now what is remaining in terms of I would say in the bill is that clause around commission of suicide, because the rest are not problematic. Additional definitions of a SIM card, of a password which we recommended. So in the bill as it is, what I would say is part of what is problematic, besides what was raised earlier, is that issue of you are sending a message that is likely to cause someone to commit suicide. That one we thought it's far-fetched, and it's very difficult to prove that what I said, it is likely to cause Henry to commit suicide. How do you know how Henry reacts to say that it's likely to cause suicide? So that is, we thought that's a challenge. And maybe just to say, like I said, it's the way that act is phrased. All those offenses that I listed there with all those facts, they are all based on likelihood. Likely to cause. In criminal law, normally we talk about that you have committed an offense because an effect has been realized, or you're likely in the reality, and it's an objective way. You are driving in a reckless manner that you are likely to cause death. If you are like the guys who are driving to Nyeri the other day, finally they caused death, but they could have been charged. You remember that matatu that was was, I think it was shown on the social media. It was solving like this. There's an objective scientific evidence that if you solve a vehicle like this, scientifically, it can actually crash. And it can cause death if you carry people. So that is scientific. So most of the offenses around in this act, they are not based on that objective criteria. It's all about likely to cause fear. The fear of violence. Like now the one for cyber harassment. It's likely to cause fear, apprehension or fear of violence. So that alone would put you in for 10 years or 20 million fine. So that is now the problematic aspect, which I think is what we need to review and engage, because that's where now the infringement of human rights is. And you can see people are already being charged. Same case with what we mean by fear and likelihood. You see, and people have been charged already, where government says that if you see that there is hunger, there's even a chief, I think it was in Rift Valley, who said that there was either a mudslide or there was a disaster. And they were challenged because you're being told that what you said is likely to cause hatred against the government. Someone else was charged another day that whatever you're saying, remember the deaths around the Gen Z time, right? That by saying that young people are being killed, you are saying that the government is killing its own people. So you're being genocidal. Therefore, then you are causing fear or likely to cause fear. So again, that is again what you're saying about the loopholes, the gaps around the whole of this legislation. And the question is, if I say that without the internet, is it an offense? And to what extent is it an offense? So that's what I'm saying, that try to relate whatever you're saying, is it the same offense if you say it through the internet or if you say it outside the internet? Because that balance has to be there. What is the benchmark with other countries? So what we did is that we first, there was not much time between the time the bill was published and the time that the committee actually invited people to go and appear before the committee. So what we did is that we picked what is more critical, but we looked at what other countries like EU and UK that have advanced certain level of democratic values through the digital space, and that's part of the reason why we identified our recommendations. For example, the inclusion of password in the definition of identity theft. Same case with our recommendation on following the due process. Going to court before you have to take down our website. So again, we thought that is again picking from the country. But if there was more time, we could then now go to other countries. And if we are now looking at the entire act, we now can even go to look at other countries and benchmark on an entire act and how they cover that. And then lastly, what would constitute an illegal post? I think that's what I would just say, the current challenge, that even by saying that there is theft in government, already it can be deemed to be an illegal activity. Or you are causing people to have fear that the government is collapsing. If you say that our economy is going to collapse, you can be charged, because you're actually causing fear and panic in the country. People are going to panic. Remember, a good part of these laws, they're based on penal code, which was actually enacted by the colonialist. And the colonialist feared the African. So anything was around fear. If you cause the government officers to fear, if you cause the government to be apprehensive, if you cause, so everything was around if you cause fear. And so anything around the posting that we are looking at, my take is that on one hand, you have to be objective. So then the messaging you're carrying is not openly untrue. You see, there are others that we can argue. As to whether the government is performing or not, that is a discussable issue. I can argue my case, I can argue my data. But there's also an next where sometimes we post the information that you also know it's not true. So that if you say, like for example, so-and-so has married a foreigner, and because the issue of discussion is about the marriage and a foreigner and citizenship. So you need to have that fact already, because that's something that is verifiable. So if you go to post that so-and-so has married a foreigner, it's something that should be verifiable. So you need to have verified before. So I think some of those things that are verifiable information, it's good for us to have that. But any other information which is more based on subjective analysis that will not be deemed illegal. Though government deems it to be illegal, because it's my perspective. If I perceive that parliamentarians are not active, it's my analysis, and that should not be deemed to be unlawful. If I perceive that CDF is being mismanaged, if I say that reallocating from hospital to a school and then the project in school was wrong, that's my analysis. It should not be deemed to be unlawful. So I think that's how I would put at it. But on one hand, partly also, there's a way some posts have also been maybe too subjective and not in a good light. So I guess maybe it's just about moderation to see what is it that are we posting and what is the purpose of posting that. Well, thanks so much. Let me not talk too much.